Hi, Sarah Jacobs here. If you're watching this video, you may be experiencing some really scary things right now, and we wanted to let you know we understand. The most important thing is your safety and the safety of your family. So if you're in emergent need of protection, please stop watching this video, call 911 or visit your local police department and let them know what's going on so that they can help you. If you're unsure if you need protection and you're still trying to figure out what a restraining order is and what it isn't and what it can provide and what it doesn't help you with, then this video is for you. Today, we're going to talk about what a restraining order is, who qualifies for one, and how to get one. A restraining order is an order that protects the victim or the plaintiff from harm, alleged harm, or behaviors of the abuser or the defendant. A restraining order can often restrict contact between the plaintiff and the defendant and may also extend to contact or parenting time with children of the victim or family members of the victim. In New Jersey, domestic violence covers a wide range of behaviors from one person to another. And the statute called the Prevention of Domestic Violence Act actually identifies 19 different types of behaviors that can constitute domestic violence, including stalking, cyber harassment, false imprisonment, assault, and a host of other behaviors. It's really important to know that the court doesn't just consider domestic violence as physical harm from one party to another. It can also include emotional abuse, mental abuse, and financial abuse. And the court does take these behaviors seriously. In order to get a restraining order against someone, you either need to live with that person, have a child in common with that person, or have had an intimate relationship, such as dating or sexual, with that person. Plus, you need to be over the age of 18, or you need to have been emancipated by a court order. It's also important to know the types of the restraining orders that you're seeking so that you know what you're applying for and what you're getting. If when you first go to the police or the courthouse, your application is successful, you'll get a temporary restraining order. This protects you and potentially members of your family immediately from ongoing abuse from either the abuser or they're commonly known as the defendant. You'll have this restraining order and it will stay in place until the time of a comprehensive hearing to determine whether those restraints should become permanent. Once the hearing happens, and that's when you and the defendant will present information, witnesses, and documents to support or oppose claims that each of you may have, a court can enter a final restraining order. If the court does that, the restraints against the abuser or the defendant will be permanent. In New Jersey, that means that the restraints can't be lifted until you, the victim, ask the court to lift them, or if the defendant happens to be successful on what we call a Carfagno application. These instances are rare and usually are at a high burden to prove. But let's focus on the first step, how to get a temporary restraining order. You have two options. If it's during the workday, you can go to your local courthouse and speak to the domestic violence intake office. If it's after hours, you can call or visit your local police department. A municipal judge can hear your application and can grant you a restraining order. If, in fact, the municipal court denies that restraining order, you have the right to ask that an on-call family judge hear your application and make that determination. If you're going to the courthouse and you're talking with the domestic violence intake office, they'll ask you a number of questions and fill out an application on your behalf. Whether you're talking to the police officers or you're talking to the domestic violence intake office, it's very important that you're as detailed and as thorough as possible. While it may be painful and difficult to talk about the allegations that you're making against your abuser, it's important that you do so with specificity, with as much dates and context as possible. And if you have any photos or documents, text messages, or anything that can help support your claims, it's important that you bring it with you and you show it to either the courthouse staff or the police officers. It's also really important that at the time you're making this application, you provide either the courthouse staff or those police officers with a history of any domestic violence which may have happened in the past between you and your abuser. Even if you didn't report that abuse when it happened, it's relevant now. Make sure you give as much history as possible and as many dates and times as you can recall. If you don't tell them about it at the time you make your original application and you go to a final hearing, you may not be able to testify to it on the day that the judge is actually listening to your full story. You want to make sure that if there's a past history, you're including it at the beginning. If the court grants your temporary restraining order, they're supposed to have that hearing, that final hearing, within 10 days of the original restraining order. Sometimes that date gets moved either by your request or the defendant's request, but ultimately that hearing will happen. As I said at the beginning of this video, your safety and the safety of your family is most important. If you need emergent protection, please call 911 or visit the police station and ask them for assistance. If, however, you think you qualify for a restraining order and it's not emergent right this second, we are here to help. Contact us and we're happy to direct you.